very good morning to everyone. My name is Sunjamin, metric number 2794333. Today, me and my fellow teammates will present the topic contract law and discuss about the case used in contract law. The case study we are going to discuss in this presentation is Ole v. Marlborough, Court LDT 1949. Now I will introduce to you all about what is contract law. A contract is an agreement or a bargain made between two or more persons which creates obligations that are enforceable at law. A contract refers to the agreement of the parties and the document which express that agreement. Some contracts are not enforceable unless they are in writing and signed, such as contract for the sales of land. There are 6 types of contract law: formal contract, simple contract, express contract, implied contract, unilateral contract, and lastly bilateral contract. Formal contract is a type of contract that are signed, sealed, and delivered. Simple contract can be oral contract, written contract, partly oral and partly written. Express contract is a contract that's set in words, either oral or written form. Express contract clearly states any necessary terms and conditions by both parties. These types of contract are the most common and are used daily in business law. For example, lease agreement, car buying agreements, and the contract to purchase a home. Implied contract is inferred from the acts and conduct of the parties. Implied contract is often verbal, situational rather than explicit. Unilateral contract is made by only one party, and the promisor is obliged to do anything. And lastly, bilateral contract made by two promisors and both are obliged. It is a contract made with mutual agreements to fulfill an action in return for a corresponding action. There are 6 essential elements for the formation of a valid contract, which are mutuality, capacity, consideration, legality, proper form, and also genuine assent. Mutuality means a valid contract should having both offer and acceptance. An offer or a promise of an agreement needs to be in a contract because if there is no offer, then there will be no contract. When the other party is clear with the offer, they would make an acceptance once they are clear with all the rules and regulations that being offered in the contract. Capacity means the parties in the contract must have legal capacity to do so. The person needs to have the ability to understand all the terms of the contract. Consideration means the other person would be giving back something in return. It would be considered as an exchange which would be made between the promise and the promisor. Legality means both parties have the intention to create legal relations and intended to be legally binding. Proper form means contract must be in written form and should be stated clearly and understood by both parties. Lastly, genuine assent means the party must genuinely and truly agree to the contract terms. The contract will automatically considered as void if any of these important essentials is missing. So now I will talk about the breach of contract. What is breach of contract? Breach of contract is a legal cause of action and a type of severe wrong in which a binding agreement or bargain for exchange is not honored by one or more of the parties to the contract by non-performance or interference with the other party's performance. Breach occurs when a party to a contract fails to fulfill its obligations, whether partially or wholly, as described in the contract, or communicates an intent to fulfill the obligation or otherwise appears not to be able to perform its obligations under the contract. Where there is breach of contract, the resulting damages will have to be paid by the party breaching the contract to the aggrieved party. In this case, non-breaching parties entitled to a remedies such as damages, rescissions, restitution, specific performance, and injunction. That is all from me. Thank you.
Hello, my name is Stacy Lin. So now I will talk about the fix of the case. So the case that we choose is Oli V Marlborough Court Hotel. So this hotel is a limited access English contract law decision from 1949 that deals with the aquarium clauses. So before I start for my part, there are 4 important things we should know about the facts of the case of the Marlborough Court Hotel. So in this case was talking about a woman who called Mr. Orley. Mr. Orley stayed at the defendant hotel which called Marlborough Court Hotel in the Lancaster Gate, London for a long time. So Mr. Orley and her husband checked into their room after paying for a week board in advance. So when she signed the register, so no other limits or conditions were listed that would affect her stay at the hotel. But a sign was posted in the room stating that the properties would not be responsible to any items lost or stolen unless they were given to them for safekeeping. So one day, she put her room key on a rack behind the reception before leaving the hotel, as usual she did. So, but it was gone when she returned. Meanwhile, an authorities individual gained access to the hotel, snagged her room key, and stole her full clothes. So Coroner Carroll, who was seated in the grounds at the time, saw someone go in and out 15 minutes later with a parcel. But the poster had been perusing a bust of the Duke of Marlborough and has apparently missed it in the room of Mr. Orley. So the notice was not seen by Mr. Orley until after contract has been concluded at the hotel reception. So Mr. Orley decided to request reimbursement for the court costs. So as a result, Mr. Orley filed a lawsuit against the hotel for negligence in the loss of her court. But the hotel said on a notice behind the door in the bedroom leading to a wash basin which has told about the property was not themselves liable for goods lost or stolen unless submitted to the managers for self-custody. So from this, Mr. Orley claimed that the clause was left out of the contract. So notice is not a part from the contract. So there are lawsuits and agreement around Mr. Orley and the hotel.
Hi, my name is XIAN, machine number 2796990. I will talk about issue of the case. Notice put up in bedroom do not themselves make a contract, unless the notice was displayed at the reception desk or otherwise up front. It could be added to the contract at a later time. The exclusion clause must be introduced before or at the time of the contract. Not only must the terms be introduced before or at the time of the contract, the party to the clause must be made given of the exclusion clause must be reasonable. In other words, the party subject to the clause must be made necessarily aware of its existence before or at the time the contract was formed.
Hi, my name is Wong and now I'm going to present about the holding of their cases. Firstly, they held that the hotel had been negligent and their negligence caused customer a reasonably foreseeable damage. Secondly, the notice could not become a part of contract. Since the contract between the parties had been established at the dress reception desk when Mrs. Ollie paid and in return received the room key. At the same time, Mrs. Ollie could not have been aware of the notice display in her room. Lastly, the terms of the clause were not plain enough for the court to be effective. Therefore, in the final judgment of Ollie v. Melbrook Court, Mrs. Ollie claimed for her court recovery was successful. The successful is because Mrs. Ollie isn't able to notice any rules and terms that have been put on the entirety wall after she signed and the staying contract and take the keys from her room from the front office. Now, I am going to present about the rationale of the holding. In my opinion, I agree with the holding made by the court according to Mrs. Ollie cases. One entity have the responsibility to put in the contract law in black and white in the contract to let their customer know about it. It is not relevant to only putting the law on the wall where the customer won't notice it, even walk in front or walk by. From the situation above, I agreed that the entity have to take fully responsible on the holding made by the court on the cases.
The conclusion of the case is a contract should be considered concluded if an agreement has been reached on all the essential terms of the contract among the parties in the form required in appropriate cases. The essential terms are those on the subject of the contract. Terms that are named in a statute or other legal acts as essential or necessary for contract of the given type, and also all those terms with respect to which by declaration of one of the party an agreement has been reached. Contract law must be written clearly so that both parties is on the same page and not causes any misunderstanding. Any of the parties who want to rely on a contract to exempt themselves from their common law liability must prove that there was a written document signed by the party to be bound, a written notice specifying the terms handed to the party to be bound before at the time of the contract, a permitted private notice before or at the time of the contract. That's all for me. Thank you.